Thank you so much for joining us, everyone. It's always a pleasure to collaborate with the Massachusetts Charter Public School Association for events such as this uh, webinar. Today, we are going to be discussing employee leaves of absence, both generally and with respect to some particular considerations for public school employers, particularly charter school employers. So with that, my name is Bettina Toner. I'm a partner in the Education and Employment Practice Groups at Krokidas Bluestein, where I represent Massachusetts public charter schools and other public and private educational entities and a wide range of student services, employment, and litigation-related matters. KMB, a little bit about the firm for those of you who are not familiar with KMB. We're a full-service charter school and education practice, or we have a full-service charter school and education practice providing advice and representation in the areas of governance, student services, employment, civil rights, compliance, contracting, public procurement, and real estate acquisition. We also do finance and development. So as I said, we're a full-service firm for charter school clients and other educational clients. Joining me today is my colleague, Jill Meixel, and I'll hand it over to Jill, who can tell you a little bit about herself.
Good afternoon, everybody. My name is Jill Brenner Meixel. I am a partner and the head of the employment practice at Krokidas Bluestein and the co-head of the litigation practice here. My practice involves the representation of for-profit and nonprofit employers in compliance, counseling, and litigation matters. We're thrilled to be here today, and thank you all for joining us. And with that, I'll turn it back to Bettina to go over the agenda.
Thanks, Jill. So before we dive in, a few housekeeping matters. So I will give our standard legal disclaimer that the material that we will be presenting today is for informational purposes only and is not intended to constitute legal advice. Any actions taken based on this presentation should be done in consultation with counsel. I want to thank those attendees who submitted questions ahead of time through the registration process. We got a lot of really great, thoughtful questions. Jill and I have attempted to roll in as many of those questions as possible into the presentation. Time permitting, we'll try to get to some additional questions that are not captured in the presentation material. And for those questions that we didn't get to, we will aim to get a Q&A document out to folks in the next couple of weeks. In addition, after the presentation, we will be circulating both the slide deck and a link to the recording of today's presentation. So you'll get some goodies after the presentation, and we do hope to get to as many questions as possible. The other thing is during the webinar, there's a Q&A function, so you have the opportunity to, if you didn't get a chance to ask your question, you can answer it in the Q&A that shows up anonymously. Our assistant Claire will be tracking those questions as well. So you still have, if you have questions that come up while we're doing the presentation, feel free to pop those in the Q&A. Okay, and with that, let's get to the agenda. We have a number of things to cover this afternoon. There we go. So today we will be covering a number of things, like I said. So first we'll start with an overview of the most common types of leaves of absence. So we'll talk about the Federal Family Medical Leave Act, the FMLA. We'll talk about the Massachusetts Paid Family Medical and Leave Act, the PFML. We'll also talk about the Mass Parental Leave Act. We'll spend some time talking about intermittent leave. This is an area that we get a lot of questions on here at KMB, and I'm sure that you deal with that in your school environment as well. So we'll spend some time talking about some of the nuances of intermittent leave and also reduced schedules. We'll also talk about other job protective leaves of absence as well. And we'll spend some time talking about leaves of absence as a reasonable accommodation under the Americans with Disabilities Act. I think there is some confusion around oftentimes between PFML and accommodations under the ADA. So we'll spend some time talking about those areas, and we'll also talk through some examples giving some examples of situations that I see in my charter school practice that Jill sees in her practice as well. And we'll kind of work through those. And then lastly, we'll talk about the intersection between performance, employee performance, and medical issues. And as I said earlier, we'll aim to get to some additional questions at the end if we have time. And with that, I'm going to hand it over to Jill, who's going to start with an overview of leaves of absence.
So this is just a general overview of leaves of absence. So employees take job protected leaves of absence for various reasons, including for parental and bonding leave, for an employee's own serious health condition, for the serious health condition of a family member. And there are many applicable leave laws that apply. At times, multiple laws may apply to one particular leave of absence, but some of the laws we're going to talk about today and explain in more detail are the FMLA, the PFMLA, which is Massachusetts' version of the federal FMLA, the Massachusetts Parental Leave Act, the Americans with Disabilities Act, and we're going to talk about some other job-protected leaves, including domestic violence leave. So now I'm going to jump right into the Massachusetts Paid Family Medical Leave Act. And we're now about 5 years into the implementation of the Paid Family Medical Leave Act, which went into effect in January of 2021 after being enacted in 2018. So before I get to the slide in front of you, I'm going to just talk about some key components of this law that are really important for you to understand. So first, I want to discuss the administration of the Paid Family Medical Leave Act. So the Paid Family Medical Leave Act is administered in two different ways, which really depends upon an employer's preference. The first way is an employer can have employees submit their paid family medical leave applications through the Department of Paid Family Medical Leave, which was created after the Paid Family Medical Leave Act became the law. The second option is some employers opt to have a private insurance plan for employees, which administers the PFMLA for you. These claims are submitted by employees as claims and go through insurance. So this would sort of be like a claim that was submitted under short-term disability, for example. But these types of claims do not go through the Department of Paid Family Medical Leave or through the employer. And I will say that very important point, regardless of which approach you as the employer choose, it's critical to understand that you as the employer do not make the decision as to whether an employee qualifies. That is a determination that's made by either the Department of Paid Family Medical Leave or by the insurer, both of which use the applicable state law and guidelines. So that's important for you to understand. Another very important point that's not on this slide, but I just want to highlight is that it's important to be aware of employer notice requirements. So employers have to provide certain required notices to employees to inform them of their rights under the law, including their contribution rates. So the Paid Family Medical Leave statute, which is Mass General Law, Chapter 175M, Section 4, requires each employer to issue to each employee not more than 30 days from the start of the employee's employment certain information which is detailed in the statute, which includes a whole variety of things, but the key ones are an explanation of what paid family medical leave is, what the employee's contribution amount is, what the employer's contribution amount is, and instructions about how to file a claim for family medical leave benefits. It's important to note that delivery of this notice is deemed effective when an employee provides written acknowledgement of receipt of the information, or when they sign a statement indicating that they refuse to sign such acknowledgement, which I don't actually think happens very often, but that's what the statute says. It's critical for you as the employer to ensure that the employee signs a notice to ensure receipt. I will note that for current employees who've previously signed a form, employers must provide information on any new contribution rate that goes into effect 30 days in advance of a rate change. This notice may be provided electronically, and unlike that initial notice that you're required to provide within 30 days, it doesn't require an updated signature. So, practice pointer for all of you is that there are sample notices on the Paid Family Medical Leave Massachusetts website. There are two different notices, one for employers who have under 25 employees and one for employers who have over 25 employees. And while you could create your own notice form, I suggest that these forms work perfectly well and they're easy to use, and you don't need to create a document when the state has already provided you with a sample. So I'd encourage all of you to look at those forms. If you're not routinely providing notice to your employees about this law, it's really critical that you do so. So with that being said, now I'm going to get into sort of the meat of the Paid Family Medical Leave Act, separate from sort of the procedural component. So who qualifies for paid family medical leave? So employees qualify for paid family medical leave if they establish two different things. And as I said at the outset, you as the employer aren't required to determine an employee's eligibility, but it's important that you understand what the requirements are. So the eligibility requirements involve two factors. One is a financial eligibility requirement, and the second is whether they have a qualifying reason for leave. So I'm going to talk a little bit now about the financial eligibility requirements for paid family medical leave. So an employee must meet the minimum earnings requirement that's annually established by the Department of Unemployment Assistance. In 2026, this was $6,300 during the last four completed calendar quarters. So the earnings requirement really isn't that high. I think even if somebody hasn't worked for a long time or hasn't made a lot of money, they could still qualify for the financial eligibility. In addition to that first component, an employee also must have earned at least 30 times the benefit amount that they're eligible for also during the last four calendar quarters. So I want to highlight here that the Department of Family Medical Leave uses the employee's base period earnings to determine what the employee's individual average weekly wage is. So what is an individual average weekly wage? So what that is it's the average amount that an employee earns per week during the highest earning two quarters within the last four completed calendar quarters before the benefit year. So the base period is, as I talked about a moment ago, the last four quarters that an employee completed and was paid prior to the start of the benefit year. So in 2026, as you may be aware, the maximum weekly benefit amount was $1,230.39. This amount tends to change annually, so you should pay close attention to the website and the notices that you get so that you can adjust appropriately. So now I want to talk about top-off. So there was one very important legislative change that happened a little over 2 years after the paid family medical leave went into effect, and that was top-offs. So this is an important amendment, and I think it has helped employers in some ways, but it's also made the calculations a little more complicated. So what this change did is initially when the Paid Family Medical Leave Act was enacted, employees weren't allowed to use their PTO, whether it's sick time or vacation time, to top off their weekly benefit amount. However, in November of 2023, the law changed. Presently, employers who receive benefits now can top off their benefits to reach 100% of their wages with any available accrued paid time. So this allows an employee, I talked about the individual average weekly wage on the last slide, and this really allows an employee to, beyond the $1,200 that they may be entitled to if they qualify for it, if they make $1,500, for example, they could use their PTO to top off that amount and get to their individual average weekly wage and get to essentially, make the wages that they were making before they went on leave with a combination of the PFMLA benefit and their PTO. Qualifying reasons for leave. So we just talked about the financial requirements for qualifying for PFMLA, and now let's talk about the qualifying reasons for leave. So an employee may be eligible to get up to 26 weeks of leave in a benefit year. A benefit year starts on the Sunday prior to when you take that first leave. So While you can get up to 26 weeks in a benefit year total, there's a maximum of 12 weeks of family leave, and encompassed within family leave is bonding leave after you have a child or adopt a child, and also leave to care for family members with serious health conditions. In addition, you could also be entitled to up to 20 weeks of leave for an employee's serious health condition. So this is if you get sick, an employee gets sick, they're eligible to take up to 20 weeks. Again, you can't take more than 12 weeks of family or more than 20 weeks of serious health condition, and the maximum per benefit year is 26 weeks. Okay, so now I want to talk a little bit about intermittent leave, which is an issue that comes up very frequently, and it's an issue that poses some great challenges for employers in particular. What is intermittent leave? So what intermittent leave is where an employee gets seeks leave under the Paid Family Medical Leave Act for intermittent leave, which isn't a set time period. So it's very different from a reduced schedule leave. What it essentially means is where an employee, let's say they have a chronic condition, and let's say that the Department of Paid Family Medical Leave grants their leave for, I'm going to give an example, for let's say up to 2 days a week for 6 weeks. This can pose very serious challenges for an employer because there's a complete unpredictability around when an employee may or may not take leave. There's not a specific time. If somebody has a chronic condition, they may not know exactly when that chronic condition will flare up. I will say that this is an area where, in my opinion, there really needs to be some sort of legislative fix, because oftentimes intermittent leave, particularly where there's no notice in advance or more than the morning before they're supposed to come to work, it can pose real problems and challenges and burdens on an employer. However, unlike the Americans with Disabilities Act, which we're going to address in a little bit, there's no provision that allows you to engage in an interactive process and evaluate whether there is an undue burden with respect to intermittent leave. So once the department grants intermittent leave, an employer really needs to work hard with the employee to ensure that it works out, even though it may cause some challenges for the employer. In other words, as we're going to discuss in a little while, with the reasonable accommodation analysis under the ADA, an employer could try to work out a situation that works well for the employer and doesn't pose an undue burden. However, the PFMLA is lacking in an analysis in that regard. An employer really doesn't have an opportunity to say, you know what, this isn't going to work out for us, so we're going to deny it. So in that circumstance, it's really important for you as the employer to communicate really, really well with your employees to try to work it out so you can get through this time when they need to take some time off for their health condition. And actually, I will add one more thing, which is, as I mentioned a moment ago, reduced schedule leave is different from intermittent leave. So that would be a situation where the department or the insurer says you can take every Tuesday and Thursday off for 6 weeks. I think that's a little easier for employers to deal with because you know exactly when they're going to be out, and you can sort of work with the employees, as opposed to the intermittent leave, which poses more challenges. And particularly the Department of Paid Family Medical Leave does not hesitate to grant those, but they don't always consider the impacts on the employer. So with that, I'm going to turn it over to Bettina.
Thanks, Jill. That's such a helpful overview of PFMLA. And so I think it can be helpful to give some specific examples or talk about some of the considerations that come up with respect, not uniquely to schools, but examples of things that come up in my practice and that I have often received calls about from schools. So I did want to first mention the issue of private insurance providers versus the DFML. So many of our charter school clients have private PFML providers that administer their PFML. Some considerations or things to think about. So just as a note, if you can have a private provider for all of your PFML, or you can have a private plan for medical leave benefits and use the state for family leave benefits. I did just want to flag for folks, if you're switching between the DFML and private provider, there's a notice requirement. So just make sure that if you have questions about that, or if you're making a switch in either direction, that you comply with the notice requirements. As a practical matter, some things to just keep in mind. Different providers administer things differently. And so I have seen some issues come up with some private providers where they say approved an intermittent leave for someone, and so the person's approved for a 2-day-a-week schedule, or let's say a reduced schedule, but then they're not coming in at all. And so then when the school calls and says, you're supposed to be here on Tuesday, where were you? They get a doctor's note and submit that, and the private provider backdates it to a full leave, which obviously can create some administrative challenges, particularly if the individual is in a student-facing position. So my suggestion there, I don't know if I have a good answer for those types of situations, but other than to just maintain good communication with your private provider, if you have one, it can just make things a lot easier. And particularly if there are switches in the midst of a particular person's leave, just staying in communication can be really helpful. So one of the questions that we got from folks were, one of the questions was about how to deal with how are summer vacations and school vacations counted for purposes of PFML. So summer and school vacations are not included in the calculation of the week's amount of leave. So that's just something to keep in mind. Usually, if you have a private provider at the beginning of the school year, the school provides the school calendar to your private provider, but those are not counted in the calculation. So if someone has 12 weeks off, and it starts 3 weeks before the school year ends, that would pick up again for the remaining time at the beginning of the school year. I'll talk about, so obviously there are coverage issues when when individuals are out, employees are out on leave, particularly in student-facing positions, right? So classroom teachers, how do you deal with an intermittent leave schedule where someone has a late arrival for example? I'm going to talk through those particular examples and some suggestions on how to deal with those. Generally, however, with respect to intermittent leave, an employee, as Jill mentioned, must work with the employer to reach a mutually agreeable intermittent or reduced work schedule. So an employee who is approved for and takes leave on an intermittent or reduced leave schedule and who fails to work during the times or on the schedule agreed to may be subject to employer discipline. There are some nuances here, though. So if someone's has an intermittent leave schedule for their own serious medical condition, and for example, they are approved to have an intermittent schedule because every once in a while they get, once a month they get bad migraine headaches and they can't come into work that day. I mean, that's not predictable. So you're not going to be able to obviously work collaboratively on a schedule for that. But if there is an intermittent leave that's approved for, say, an employee to take a parent to or a child to medical appointment, and they are, say, so I think of an example that has come up in the past where someone's approved to, the policy of the school is that teachers come to school 30 minutes before school starts, or 30 minutes before their teaching responsibilities start. An employee has an approved leave for to come 15 minutes late. So instead of coming 30 minutes, they come 15 minutes late to accommodate a medical appointment. But they're routinely not coming within the 15 minutes, and they're actually coming after the start of when they're supposed to teach. That's a situation where you've agreed upon a schedule and the employee is not complying with it. In those cases, you might need to treat that as an employee discipline matter. So all it is just to say these issues do come up in a variety of circumstances. And as we'll talk about in a minute, there are some pitfalls or things to be aware of with respect to retaliation. So when you have questions, it's always good to reach out to counsel or to your HR specialist before you make a decision about how to handle something, because there can be consequences. So with that, as many folks know, there is or maybe you don't know, but many folks do know that under the PFML, there is a presumption of retaliation. And what does that mean? That means that any negative change in seniority, status, employment benefits, pay, or terms of conditions during a job protected leave or the 6-month period following leave is an automatic presumption of retaliation. So, in other words, if you are taking an adverse employment action against an employee within the 6-month window after they return from a job protective leave, there's a presumption that you are retaliating. Now, that presumption is rebuttable, but it is a high bar to rebut it. So it can only be rebutted by what's called clear and convincing evidence, which is a high standard. You have to show by clear and convincing evidence that the employer's action was not retaliation against the employee and that the employer had some other sufficient independent justification for taking that adverse employment action. That is a high standard, but it's not insurmountable. And I think it's important to mention because I know that Jill and I have talked about this, that oftentimes we get calls from schools or other employers, and they just assume like, well, we're really having an issue with performance for this individual. It was a problem before they went out on leave, that's a problem now that they're back. But we feel like our hands are tied. We can't take any disciplinary action because we're within the 6-month window. You do need to be cautious. There is a presumption that is retaliation, but it is rebuttable. And so I do think it's worth mentioning that because I feel like even recently I've had some examples with schools where folks have called with that type of scenario, but the evidence has been so compelling that the school has felt that it needs to take action. And so we've sort of talked through it, and it really goes to something we'll talk about in a little bit, which is the importance of keeping good documentation. So if you have strong documentation about performance or other, misconduct, etc., that will help you overcome the presumption of retaliation. So just something to keep in mind. It doesn't mean necessarily that you can't take action, but you should proceed cautiously. All right. So other types of leave. So we talked about that. So in addition to PFML, under Massachusetts law, as Jill mentioned earlier, there are other types of leave. So there's leave under the FMLA. So this applies. Most of the schools that are on the call have more than 50 employees. It provides for up to 12 weeks of unpaid leave in a benefit year. Leave can be for bonding, to care for a family member with a serious health condition, for the employee's own serious health condition. There are eligibility requirements, just as there are with PFML. Typically, where an employee qualifies for leave under PFML, FMLA leave will run concurrently. But it's important that your policies say that. So we always advise, for when you're doing your handbooks, when you're doing your policies, we look for this when we review school policies, school employee policies. Make sure it's clear that they run concurrently. As a practical matter in Massachusetts, anyway, FMLA will be subsumed under PFML, but you want to make it clear. You don't want a situation where someone is on leave for 20 weeks and then comes back and says, I want another 12 weeks of unpaid leave under FMLA. So just make sure it's clear that they run concurrently. And ensure, again, that your policies clearly state that that's the case. And again, as Jill mentioned earlier, there are other types of leaves, such as the Massachusetts Parental Leave Act. This is 8 weeks of unpaid leave to a parent, regardless of gender, after the birth or adoption of a child. Eligibility requirements. Again, this would apply to most of the schools on the call that have more than 6 employees. Limits if both parents work for the employer. Again, where we have an employee that would otherwise qualify for PFML and FMLA leave, this would run concurrently as well. So the tip is, again, to ensure that your policies clearly state that they run concurrently. It's very important. When would this apply? If it just runs concurrently with PFML and FMLA, it could apply when you have a new employee, for example, that doesn't qualify for PFML or FMLA. That they may not have recent work history or not otherwise meet the eligibility requirements, but this is an additional type of leave that's available for folks. Other job protected leave. So domestic violence leave, these are, again, under Massachusetts law, domestic violence leave for for employees. Again, all of this should be covered in your handbook, so it's clear to your staff that they have these options available under state law. But 50 plus employees, you have domestic violence leave. Leave has to be directly connected to abusive behavior, up to 15 days off in any 12-month period. Also, small necessities leave, again, also unpaid time off for certain situations like child's medical appointments or school conferences. Employees can use PTO if they want. So this is unpaid time. If they want to use paid time, typically you would have your policies be clear that they could use PTO for these types of appointments or commitments. And with that, I will hand it over to Jill, and we will switch over to talking about reasonable accommodations.
So much, Bettina. So now we're going to turn to talking about reasonable accommodations under the ADA. And I will say that this is an area that I probably get the most questions about, and it's an area where I think there's the most confusion about how reasonable accommodations, particularly when you're talking about a leave of absence, how that plays into or connects with sort of a PFMLA leave. So this is, again, it's very nuanced. It's very fact specific, but hopefully this overview will help you sort of understand where the ADA comes into play, particularly after somebody has finished a leave under the Paid Family Medical Leave Act. So with that being said, just to back up, what is a reasonable accommodation? You've probably all heard of it in different contexts. What it is it's a change in a job or the way it's performed that allows a disabled employee to perform the essential functions of the job. So it could be something like if somebody has carpal tunnel syndrome and needs a new keyboard, or if somebody has back problems and needs a different chair. But it could also be something like a leave of absence. So what do you do when an employee says, I need a reasonable accommodation? How should you, as the employer, respond to that? So your fundamental obligation with respect to a request for a reasonable accommodation is to engage in the buzzword, the interactive process, in order to determine whether there is an accommodation that will allow the employee to perform their essential job functions without causing you an undue hardship. So I talked earlier about how the undue hardship analysis doesn't really play in because of sort of the way the law is written to the PFMLA. But after somebody's taken a paid family medical leave, or if they're not eligible for it, this is where you as the employer can evaluate an undue hardship. And I will say it's critical to document this interactive process, because you may get to a point where you have to deny somebody's request, and you want to make sure that you've documented it to reduce any liability risk in the future, to show that you've engaged in the process. Maybe you proposed an accommodation that was reasonable and the employee said, no, I want a different accommodation, to show that you've really worked with the employee. I will say that as the employer, you have a right to determine what a quote unquote reasonable accommodation is, with guidance from the employee's medical professionals, et cetera. But it's not the employee's right to choose which accommodation is reasonable, but it's your obligation to sort of be educated as far as like which accommodations might actually work in this particular situation. So as I said a moment ago, reasonable accommodations come in all different forms. It could be accommodation to workplace conditions, like I mentioned, the keyboard or the different chair. Or it could be something like a modification of job duties. Maybe somebody, has PTSD and needs needs somebody to come up with a framework for how they're going to do their assignments every day. Or maybe somebody has, another medical condition that requires you to sort of think outside the box as far as what can you do to help this employee to perform their job, if there is something that you can do. And then another form of a reasonable accommodation that, again, this comes up a lot, and I don't think that folks fully understand, that a leave of absence, even though you're not really performing the quote unquote essential functions of your job because you're not there, it can be a reasonable accommodation. There's lots of court decisions on this, and it's really important for you to understand that where there's not some other paid leave or protected leave that comes into play, like FMLA or PFMLA, the default always is to next, before you terminate, before you say, no, we can't let you be on leave anymore, stop and think about a reasonable accommodation. I will also say that an employee might not know those buzzwords, reasonable accommodation. So if they ask you for a new chair or a different chair or a different keyboard, that's sort of them saying, like, I need something to help me perform my job better. It doesn't necessarily have to be the exact words, reasonable accommodation. So with that said, next slide. Thanks, Bettina. Okay, so I've just sort of gone through this a bit. So as I mentioned, a leave of absence can be reasonable accommodation under the ADA. When does this come up? This comes up in a variety of circumstances. It comes up probably most frequently when somebody has finished a job protected leave, whether it's PFMLA or FMLA. So let's say an employee has taken 20 weeks of PFMLA for a serious health condition and they're not quite ready to come back. It could also apply where somebody isn't eligible for FMLA or PFMLA. Maybe they have only worked for you for 2 months and they were previously a student and didn't have any income. So it's a situation like that. Somebody might ask you for a leave for a health condition. They're denied from the Department of Paid Family Medical Leave. Again, that doesn't mean if they need to be out for a couple months, you should automatically terminate them. I will say that we've had circumstances where employees have only been employed for an extremely short period of time, let's say a week, and they ask for a reasonable accommodation. A consideration isn't how long they've been employed. So, I mean, again, it maybe is something to sort of look at the big picture, but you can't say, oh, they've only been employed for a week, so we're not going to grant it. Or this person's been employed for 3 years, so we will. You really have to look at the facts and circumstances surrounding the accommodation. It's not so much, when do they ask, how long has the person been employed? And with that, the next slide. Okay, so what exactly should you do if the example I just gave, somebody's been out on paid family medical leave for 20 weeks, they come back and they say, I can't come back, I'm not ready. What do you as the employer do in order to protect yourself and reduce liability risk? So the first thing you do is you ask the employee to provide information from their health provider, healthcare provider, that includes certain pertinent information so that you can evaluate whether to grant a request to take an additional leave of absence beyond the 20 weeks of job protected leave. So the important information to ask is, what are the employee's limitations due to this disability? As you all probably know, don't ask what the disability is because that would violate the law. But you can ask, how are you limited as a result of your disability? You can ask for suggested reasonable accommodations. Ask the medical professional, what suggested accommodations do you have? And if it's a circumstance where you suspect that the person may be able to come back to work, but they're really asking for a leave of absence, you can ask the medical professional, could you please let us know what reasonable accommodations would be appropriate separate from a leave of absence? Because again, just because somebody's asking for a leave of absence doesn't mean that's the only accommodation that you can consider. Maybe they can do their job. Maybe they just need to work remote, or maybe they just need to come in on a reduced schedule. Maybe there's another way to work it out. So you don't automatically assume that, okay, they're asking for a leave, that's all we're considering. You should consider the full gamut, because you may have a situation where somebody's asking for a leave, but in fact, they can come back and with some accommodations and they say, no, I don't want that. You as the employer will have documented all of those things, and that'll help reduce your liability risk. If the employee then goes to sue because they said I was terminated in violation of the ADA, and you can say, no, I as the employer engaged in the interactive process and we offered this accommodation and that accommodation they declined. That's very helpful to you in protecting yourself and your organization and your school. And I will say, I suggest as sort of a practice tip to come up with a form, a template form. We have them, we use them frequently for clients that includes all this information that you need to seek from the medical professional. So I suggest coming up with a template letter to provide to the employee that says, dear employee, I understand that you've requested an accommodation. Please provide the attached paperwork to your medical professional. And once we receive that paperwork, we will evaluate whether we can grant the accommodation. So once they receive that requested information, and I think this is on the next slide. So once they receive the information from the employees, and now the information's back, what do? You evaluate the information you received. You look to see, are there any alternative accommodations other than a leave of absence? If they're asking for a leave of absence, how long? Are they asking for a leave of absence for some indefinite period of time? Are they asking for a month, for example? If they took a prior leave under the PFMLA or otherwise, how long was that leave? The interactive process here, as I indicated at the outset, is really critical because it'll protect you if an employee just won't budge and there are accommodations available that they're not willing to accept. And then you make a determination as to whether or not you can grant that leave. You will be considering, and I'm going to turn it over to Bettina in a second, whether or not the additional leave creates undue hardship, which is a fairly heightened standard. But in the meantime, if you don't need to sort of evaluate that, if you think you can work with the person, you can then send a letter to the employee saying, we've considered your request for a reasonable accommodation, and we will either grant or deny the request, and make it very clear. It's critical to document, because these things can sort of go on for a while, and the more documentation you have, the more you're protecting yourself as an organization. But the key point here really is that if somebody has been out for 20 weeks on PFMLA and they can't come back, the last thing you want to do is say, I'm sorry, you're terminated. You need to, if they're asking for an extension of that leave for the same medical reason or another medical reason, you need to stop and evaluate that request very carefully, even if your first thought is, we just can't take it anymore with this person not coming back. They've already been out for 5 months. So with that, I'm going to turn it over to Bettina to talk about the undue burden analysis, which is a way that you all as schools can potentially push back on providing somebody with a further leave of absence.
Thanks, Jill. So undue hardship. So consider whether the reasonable accommodation, as Jill mentioned, will pose an undue hardship on the employer. So schools ask about this a lot, right? So I think, as most folks on this call know, if you are a school employer, there are unique elements to employees of a school. So when you're considering whether reasonable accommodation will impose an undue hardship, you want to consider a few things. So the first is the significant difficulty, whether there's a significant difficulty or expense to the school, looking at the resources and circumstances of the school relative to the cost and difficulty of providing a specific reasonable accommodation. And I'll give some examples. I know I'm going to give a lot of hype for the examples, but we'll play this out in the examples to walk through kind of what that analysis looks like in the school context. But it also refers to undue hardship, also refers to financial difficulty. So how much is it going to cost the school or the employer to provide the accommodation? Is it going to be like de minimis, or do you have to hire another employee for some particularly lengthy period of time to cover this person's responsibilities? So financial difficulty, the accommodations unduly extensive, substantial, or disruptive, even putting aside the financial difficulty. So there are different elements of the request that need to be examined when you're considering whether this is truly going to be an undue hardship or not. Again, the nature of the school's operations is relevant. Are you talking about someone who's asking for an extended unpaid leave of absence during the school year and they're a teacher? Or is it an administrative person who you have other folks to cover their job responsibilities, even if they're going to be out for a lengthy period of time? Or is it like your only PT for the school? All of those things are going to be things to consider. And as Jill alluded to earlier, generally open-ended leaves are generally not considered reasonable. So there's case law on this. If the employee says, I need to be out, and I'm not sure when I can come back. This actually comes up fairly often, or at least I felt like last year this came up as an issue a lot, where someone was, perhaps in rehab and was getting out, but they weren't exactly sure when they'd be able to come back, and they were out of PFML time. So they knew that they needed time, additional time, but they just didn't know when they'd be able to come back. And for obvious reasons, this causes, this can cause hardship for a school as you're trying to plan for the next school year. You may have already hired someone to cover that person's position. So generally, open-ended leaves are considered, are not reasonable, would create an undue hardship. The EEOC has issued some guidance on what it means to have an undue hardship. The guidance says that generalized conclusions will not suffice to support a claim of undue hardship. In other words, you can't just say this will be an undue hardship. You need to have a factual basis for making that determination. So instead, undue hardship must be based on an individualized assessment of the current circumstances that show that a specific reasonable accommodation would cause significant difficulty or expense. Again, going back to Jill's points on the interactive process, this is why documentation is so important, because you need to be able, if you get a lawsuit down the road or a challenge, especially, time goes by, like Jill said, you want to be able to look back and say, oh, we did engage in the process and we did determine based on these specific facts and circumstances that this would be an undue hardship. So really important to make sure that that's an individualized assessment. EEOC guidance, some more on that. So some factors that the EEOC has said that an employer should consider when making a decision about determination of undue hardship. You would look at things like the nature and cost of the accommodation. We alluded to this a little bit earlier. The effect on the expenses and resources of the programs of the school, the overall financial resources size and number of employees, and the type and location of the facilities of the employer. The type of operation of employers. So again, the nature of school operations is important many times in making a determination about whether an accommodation is reasonable, and the impact of the accommodation on the operation of the facility, or in other words, of the school. All right, so as promised, some examples. Many of you may have had some of these types of situations. But Jill and I try to think through, some examples of things that come up in the school context. So I wanted to just walk through a few of these. Here we're going back to, or just to reorient ourselves. We're sort of going back to the intersection of PFML and reasonable accommodations in situations where these things may come up. So take an example where you have a full-time teacher who is on PFML leave. Their leave expires, so they've used all of their PFML time, but they're not ready to come back. So they've requested, as a reasonable accommodation, part-time work. And so you engage in the interactive process, and you need to make a determination as the school employer whether part-time work is a reasonable accommodation or not. There's actually some case law on this. And again, I just want to reiterate, there's case law on a number of these different situations, but you still have the obligation to have an individualized analysis when you get these requests. So I don't want anyone to come away from this saying like, part-time work is never a reasonable accommodation. There is some case law that has said the question of whether whether full-time work is an essential job function of a teacher is essentially a question of fact, right? So this is going to depend on the specific teaching role. And so, you could have a situation where where it could be a reasonable accommodation to allow someone to work part-time for some period of time as a reasonable accommodation. Now, that said, there is also a recent case, also from the Federal District Court of Massachusetts. This is the Sarkissian case. I have the notes on the next slide, where the court found, this is Federal District Court, found that regular in-person attendance was an essential function of the role of a teacher. I will just note again, though, the facts in that particular case where that was a private school, and that particular case, the teacher had a teaching caseload of 5 English classes, and also served in a number of other roles. So serving as a student advisor, there was an expectation that faculty attend a certain number of school meetings in person. In that case, the court said, so that case, the teacher was looking for an extended leave and some remote work, I think. And the court said, in that case, based on those facts, that in-person full-time work was an essential job function for a teacher. But again, I think it's going to depend on the particular, again, we're talking about teacher, right? That's going to depend on the particular individual and what the scope of their job responsibilities are. This is one reason to make sure that you have job descriptions that are updated for all of your school roles, right? Because those are going to be important. I mean, those are important for a whole number of reasons that we could do a deep dive on job descriptions, right? And why they're important and what to include in them. But if in-person full-time work is an essential function of a particular role, for example, a teacher or others, it should say that in the job description. And that will be helpful for you if at some point in time you have to make a determination that part-time work is not a reasonable accommodation. Because again, it's going to be based on the facts and circumstances. And this isn't if someone, has a teaching role, but there may be, I don't know, a reading coach and they could do that virtually. That might be, remote work might be a reasonable accommodation. So just some examples just to note, the analysis and some of the things to think about and why job descriptions can be particularly important when you're hiring folks. Okay, so remote work, that's another one that we get. questions about a lot, particularly since COVID. There's some case law on this, which has, from both in Massachusetts and out of state, where courts have said that remote work for a teacher is not a reasonable accommodation, that certain student-facing positions, an essential function is being there in person. Again, this is a particular example is talking about a teacher. This analysis might be different if you're talking about a school administrator. Now, again, it might not. It might be important for your school administrators, particularly if you're talking about a school leader or CEO or, some other important leadership position to have folks be on campus, for their performance of their job duties. But there may be others, or custodial management, a facilities director, that sort of thing. But there may be other positions where remote work is a reasonable accommodation. So not to beat a dead horse, only to emphasize that it's an individualized analysis. Indefinite leave, we talked about that. So open-ended requests for accommodations generally are not considered reasonable. And I want to give the example, this is another one. So what about a late start teacher? Again, this is talking about an example with a classroom teacher who wants to have as a reasonable accommodation. They have a sleeping disorder and they have a hard time getting going in the morning, and so they want to have an 11 a.m. start. Again, we want this to be an individualized analysis, right? So are the teachers' classes, is their course load particularly, is it spread out through the day? Do they typically teach in the morning? How much of a hardship would it be to move their schedule around? Again, all of those things are going to be an individualized analysis based on the nature of the job, the school's particular needs, and who do you have that's able to cover, how long are they asking for the leave, and so forth. So just some examples that have come up in our practice, and I included just in the slide deck that you'll get as well, some reference to some of these cases that explore some of these issues. Again, importance of being clear in job description. If in-person full-time work is an essential job function, then say so. And with that, I'm going to hand it back to Joe. Yes.
Thanks, Bettina. So here's another example for you that we're just going to play out. So the example's on the slide, but employer has agreed to a 1-month extension of the employee's leave under the ADA. So let's say PFMLA expired and they're now asking for another month. What do you do? Well, the employee then reaches out to you a few days before the leave expires and asks for another month of leave. And I will say here, just to stop, as the employer, you should have a practice of communicating with your employees who are on leave more than a few days before their leave expires, so that particularly for schools where it's really critical if somebody's a teacher or administrator, you need to be able to handle your staffing. So I would reach out more than a few days before and make sure when the employee reaches out to you that you've already been in touch with them. So what should you do? Well, the first thing that you should do is you should, again, it's another request for leave, but you have to engage in the interactive process. So if they've been out for a while and they ask for another extension, again, this might be when they're coming back from paid family medical leave, or it could be, let's say they asked for a month of additional leave under the ADA and you'd already granted that. You basically need to get new documentation. So if you had documentation saying they could come back in a month initially, and now they're saying they need another month, you start all over. You have an obligation to, again, engage in the interactive process, keep your documents, memorialize your conversation, get a new medical document from the employee's healthcare professional to determine, again, the same questions we had talked about before regarding how much longer do they need for leave? Is it really a month? Are there other accommodations that might work here? What's their impairment? What's the nature of their impairment? So what should you not do? So you guys probably know the answer to this by now, but you shouldn't say, no, I'm sorry, you're fired. And again, I mean, I often do get calls from folks who haven't had this issue arise before, and they say, employee X is coming back from leave, and they say they can't come back. Can I fire them? And again, I understand where that thought comes from because the ADA accommodations in the form of leave of absence isn't something that's necessarily at the top of mind. Again, you may be able to terminate them, but before you do that, you need to go through the interactive process to see what information they provide to you. So again, kind of back to my initial overview of how to handle an accommodation, you handle accommodations the same way, whether it's the first request, second request, third request, etc. So What should your decision vary at all depending on whether the employee has performance issues? So let's say the employee had serious performance issues before they went out on leave, and we're going to address this in a second. And now they, have been on leave, and now they ask for another month. So the answer to that is it shouldn't vary. You shouldn't treat somebody differently under your ADA analysis based on whether or not they have performance issues. Again, you may have to deal with the performance issues, or you will deal with the performance issues if and when they come back to work. But in this interactive process, the performance issues shouldn't weigh into this. And lastly, should there be different considerations because the employer has already provided one extension? Yes, possibly. So the undue burden analysis that Bettina addressed a little while ago plays into this. So the longer a person takes for leave, the more potential undue burden, particularly again in the school context, in the reasonable accommodation context. And I will say I advise a lot of non-schools, and the standard schools definitely have schools, and I think healthcare professionals too. You have arguments that other employers don't necessarily have because you're teaching students, and obviously that function is incredibly important. And for healthcare professionals, if you're taking care of sick individuals and you need staffing. So I do think while the undue burden analysis is very challenging, it's very employee friendly. I think you all, based on the case law that Bettina had on the slide before, you do have more support than sort of other types of businesses, but again, you still have to be really cautious. So with that said, I think we're going to now address what I sort of just hinted upon, which is what's the intersection between performance and medical issues? And this issue also comes up quite frequently in our practice, where an employee concurrently has both performance issues and medical issues. And how should you proceed? So the really critical thing to bear in mind here is that you really have to proceed cautiously, because if you end up ultimately having to take a disciplinary action against an employee, you want to really make sure that all your documentation is tied to the performance issue, not the medical issue. Bettina discussed earlier that presumption of retaliation. So for example, if you need to ultimately, let's say for example, an employee had performance issues before they went on leave, they take a leave and then they come back, and there's that 6-month presumption of retaliation. You continue with your PIPs or whatever you're doing to address those performance issues, but then let's say 3 months into their return, it's just really not working. It's not working, and you need to fire the person. Well, if you've documented all of these issues very closely and very carefully, then you're going to have reduced your liability risk significantly, because you have to overcome the presumption by clear and convincing evidence that the reason for the disciplinary action is not connected to the protected conduct, which is the leave of absence under the PFMLA. And with that said, I think that, Bettina, I think this is your slide.
Yeah. So I know that we're close to time, so I'll just go through this example quickly just to illustrate some of the points that Jill was making. So this is an example that comes up pretty frequently in the school context and in other contexts, quite frankly. So assume the following: an employee has ongoing performance issues over a lengthy period. The employee subsequently informs the employer that they need to take job protected leave due to illness. They go out on PFML for several months. And then consider which of the following scenarios has the most significant liability risk. So scenario 1, the organization school has little or no documentation of performance issues. And this is pretty common, unfortunately. I try to nag my schools about keeping good documentation about performance issues. But I think the issue that comes up a lot is, and particularly for schools, I think when you do your performance evaluations, you want to focus on the positive, you want to focus on improvement. The flip side of that is sometimes then when you really do need to take out employment action, you have a bunch of, your employment reviews or, performance reviews have a lot of glowing reports, and there's not actually a true reflection of the performance issues. So organization has little or no documentation of performance issues. The employee comes back and then the performance issues continue. 4 weeks pass, the school calls me or Jill and says, we want to terminate the employee. What do you do? Again, this goes to the issue of, the presumption of retaliation. The flip side is the employer does keep good documentation. There's a lot of documentation around performance, PIPs, efforts to support the employee around the performance issues. The employee comes back, the performance issues can return or continue, and then 4 weeks pass and the organization school wants to terminate the employee. again, it goes back to this discussion we had earlier about the presumption of retaliation, as Jill just mentioned. It's a rebuttable presumption. So, if you want to, sometimes you just have to make those decisions, particularly if the performance issues or the conduct issues are just really egregious and you can't, it's just either not safe or just too disruptive to keep the employee employed. If you have that good, robust documentation, it's going to really support your ability to rebut that presumption if you do terminate the individual and they do bring a discrimination or other kind of lawsuit. With that, I think that was, I know that we promised to get to some questions, but I know that we're at time and I know a lot of folks are on lunch. So we promised to get out to you in the next couple of weeks Q&A document with the questions we did not get to, the questions that were asked. I know there were some questions in the Q&A. And we will be sending around the slide deck and also a link to the recording for if you have colleagues that weren't able to attend today. So thanks so much for joining us. Thanks to the MCPSA for co-hosting with us. And I hope you all have a great rest of the day.
Thank you, everybody. Take good care.